Okay, continue our coverage of filings on the Comey docket, which is super active this week. Lots of stuff to cover. I think this is going to be the last one, at least for now, that is a motion from Comey. The next filings we're going to get into on the following videos, and then the rest of episode 351 of my podcast is going to be responses from the DOJ, the prosecutors filing. And their stuff is really compelling, and I'm looking forward to covering it. So this is going to be the last one from Comey's side for now. And it's a motion for a bill of particulars. A bill of particulars in either a civil or criminal case is basically asking the other party to tell you exactly a written account of an itemized account of exactly what it is they're charged with. And that's what Comey is asking for here. And it makes a lot of sense because the indictment against Comey is super short on any specific information about what it is he's charged with. And as they've complained in other filings, and if we go and look at the indictment, this is all it is. It's just these pages right here, these 2 pages, 2 counts, and it doesn't tell you anything about the how. It tells you the when, September 30th, 2020, but it doesn't tell you the how, the what. It tells you person 1 and person 3, which we now know from other filings are Hillary Clinton and Daniel Richman. But that's about it. And it's not enough information in order for the defendant, James Comey, to create a defense for. How can you create a defense against such little information here? So that's what the bill of particulars is asking for. And I'm not going to read the whole thing page by page. For this one, we're just going to go real quick. It says then gives the background of it. It bears noting that both of the counts of the indictment appear to focus on mere seconds of Mr. Comey's testimony to the Senate Judiciary Committee at that hearing. And at that hearing, Comey provided nearly 4 hours of testimony in response to a range of questions. And given the lack of details, essential details, that are in the indictment, Mr. Comey cannot prepare a defense to this indictment. If the indictment survives dismissal, which there are 4 motions to dismiss now, I think, a bill of particulars under Federal Rule of Criminal Procedure 7F is warranted. Now, this is what I want to dig into, is what those particulars are. As to count 1, Comey is asking for DOJ to identify the date, time, and method of communication for each instance in which Comey allegedly authorized Mr. Richman to act as an anonymous source regarding the Clinton investigation. That's pretty interesting because that's the thing that Mr. Richman said never happened. Has Mr. Richman been a source in news reports? Yes. Have those news reports talked about the Clinton investigation? Yeah. Have those news reports talked about the Trump investigation? Well, they may have, but there was no such thing as the Trump investigation. Not at the time of Comey was FBI director, and not at the time that Mr. Richman was speaking back then. The relevant time period, Trump wasn't under investigation. So, and Mr. Richman says Comey never authorized him to be an anonymous source. And in fact, in all the newspapers I'm aware of, Mr. Richman is not an anonymous source. He's a named source. So this is highly interesting what the government will say about this right here, because that might be some brand new information to us anyway. B, the individuals or entities to whom Mr. Comey allegedly authorized Mr. Richman to act as an anonymous source regarding the Clinton investigation for each instance identified above. So who did he talk to? What news reports? What did those news reports say? What are those news reports? They're not named anywhere in here or in any filing so far. The substance and form of Mr. Comey's communication. This is the next one. The substance and form of Mr. Comey's communication allegedly authorizing Mr. Richman to act as an anonymous source regarding the Clinton investigation for each instance identified in 1A. So was it electronic communication? Was it email? Was it text? Was it verbal? Was it over the phone? What was it? Next, Each instance in which Mr. Richmond allegedly provided or attempted to provide information to a news publication as an anonymous source. I can find lots of articles where Richmond is a named source, but that's not the allegation here. The allegation is that he served as an anonymous source, and then Comey lied about that occurring. The individual lied about it occurring on Comey. Wait, let me restate it. You need to be careful. The allegation is that Comey authorized Richmond to serve as an anonymous source in news media that mentioned the Clinton investigation, articles that had to do with the Clinton investigation. So what are those instances where that happened? The individuals or entities to whom Mr. Richmond allegedly provided or attempted to provide information to a news publication as an anonymous source for each instance identified above. And then for count 2, which is the obstruction one, each allegedly false or misleading statement that underlies the count 2 charge. The specific question leading to and answered by Mr. Comey that underlies each statement in count 2. The factual basis for the government's allegation that each statement identified in response above was false when it was made. The factual basis for the government's allegation that Mr. Comey knew that the statement identified in response above was false when he made it. How Mr. Comey corruptly influenced the proceeding. Which inquiry or investigation Mr. Comey allegedly attempted to influence by the Senate Judiciary Committee, and specify any other ways in which Mr. Comey allegedly violated 18 U.S.C. 1505, which is the obstruction of a congressional investigation. So the purpose of an indictment is twofold. It needs to indict a person. Actually, I'm going to skip all that stuff. This is all the legal argument here. Arguing about when a bill of particulars is necessary or required or whatever. I don't think there's really an argument that one isn't required here, because the indictment is so light on any details. It doesn't really tell you anything. And it, as we learned in the other filing we covered, or you read through, it gets things wrong. Like, it's just straight up, it has flaws, has errors in it. Let me skip all this. There we go. This is the next part I wanted to get to. Yeah. Okay. Count 1 fails to provide any detail regarding the factual basis for its claim that Mr. Comey knowingly authorized Mr. Richmond to be an anonymous source in news reports regarding the Clinton investigation, including A, when and how Mr. Comey provided such authorization, and B, what Mr. Comey authorized Mr. Richmond to speak to news reporters about, and C, which news reports included anonymous information from Mr. Richmond. Footnote. Always check the footnotes. What does footnote 4 say? Although the Arctic Haze investigation identified several instances in which Mr. Richmond allegedly provided information to the media, the indictment does not indicate whether those instances are the basis for the charge here. The government produced more than 85,000 pages of discovery that include, among other things, but some not all, of the materials obtained from a wide-ranging FBI investigation across different districts and numerous articles, some of which quote Mr. Richmond by name. The voluminous discovery provides no greater clarity than Mr. Comey for any aspect of count 1. The nature of the allegation underlying the government's apparent theory of falsity, that Mr. Comey authorized Mr. Richmond to be an anonymous source for an unnamed news outlet, places Mr. Comey in an impossible position. To effectively mount a defense, he must identify every article across the world at any time after 2015, when the FBI's investigation of Hillary Clinton began, that references an anonymous source about any aspect of an investigation involving Hillary Clinton, and discern whether the government contends that Mr. Richmond was the anonymous source for that article. Accordingly, without knowing whether and how Mr. Richmond allegedly acted as an anonymous source, Mr. Comey cannot ascertain whether the government has fulfilled its obligations under Brady. For example, if the government contends that Mr. Richmond acted as an anonymous source in articles that were the subject of the Arctic Haze investigation, the defense would request that entire investigative file, which has not so far been produced, as well as information about all other individuals the government identified as possible sources of information, which has also not been produced. Footnote: as explained in the motion to dismiss, Arctic Hayes was an investigation into whether Mr. Comey had allegedly disclosed classified information to the news media through Daniel Richman. And that was concluded without criminal charges against Mr. Richman or Mr. Comey. Such materials would enable the defense to demonstrate, as government investigators previously found, that there was insufficient evidence to believe that Mr. Richman was the source of that information. And by contrast, if instead the government contends that Mr. Richman was authorized to act as a source in a different article, the defense could tailor both its Brady request and trial defense accordingly. The defense should not be required to dig through tens of thousands of pages of incomplete discovery to guess at what it is defending against, only to be sandbagged by the government at trial. The government's failure to articulate how Mr. Comey's response was allegedly false prevents the defense from understanding the specific basis of the alleged violation. Under these circumstances, count one of the indictment does not allow Mr. Comey to assess whether the government has complied with its obligations to turn over materials under Brady, let alone to mount an effective defense for trial. It's going to be similar for count two. This is, I want to see if there's anything here I want to bring up. Okay. Sorry, I'm just scanning. In short, to be able to defend Mr. Comey, they need to know the substance of the charges asserted by the government. Yeah. Okay. What really caught me out my eye here is this stuff about Arctic Hayes, because we might learn through this or get access to the rest of the Arctic Hayes file. And we also might learn information as to all the other individuals the government identified as possible sources of information. That would be fun. Because there's no doubt that some classified information got out. There is doubt about who it came from. And the Durham team, the investigators from Durham, and the U.S. Postal Inspection Service that were Tropic Vortex, and the other, I think, Washington Field Office, and there were other offices involved that were looking at the media leak investigations. The 8 of them that there were, I think. They had trouble tracking down who was leaking this classified information out, and it was getting out in a way in which it allowed the media to characterize their news reporting alongside the ICA that was weaponized against Trump, and to keep painting the picture of Trump-Russia collusion. And these leaks, I think the only one that they really did track down was this one from March 5th, 2017, where they figured out that it was James Baker and James Rybicki. Rybicki forwarded to James Baker a draft of a statement of Comey asking the DOJ to speak about Trump's wiretapping claim and tell the media that he wanted DOJ to state that the FBI had not wiretapped President Trump because Trump wasn't under investigation. And a draft of that was conveyed to the New York Times through James Baker, and James Baker said he thought that he was being told to do that and he was authorized to do that, and that was conveyed to him by James Rybicki, Comey's chief of staff. But there was nobody was ever charged for that because it was never concluded that Comey actually instructed or authorized anyone to share that. And this was another leak, that draft of that leaking. I think that's the only one that really came close to like really tracking down how it happened. and no charges were brought. Now, whether that's because it was a misunderstanding or because it got out some other way, like say McCabe leaked it out, I'm not sure. But this bill of particulars, we might learn some really, really interesting things from it. And it is necessary. We're going to see this. I'm pretty confident this is going to happen. This happened we've seen in other cases we've covered motions for bill of particulars, and what they've come back is like the government just comes back and details the defendant did this on this date. This is what they said. This is who they said it to. This is how they said it, or this is the action they took. This is how they went about that action. Here was their purpose in it. This is how it resulted in a crime. It's very pointed like that, and it's like an itemized accounting of the crimes, which is not there. It's not in the indictment, and you can't imagine trying to write your defense and plan out a defense to this right here. I mean, this is not possible. All right, on the next episode or the next video I do, I'm really excited about because we're going to get to the government's filings. The government has made several filings in United States v. Comey this week, and all of them are good. All of them contain new information and are a good read.